And we are live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before their honorable, the justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and my apologies for the late start, but I'm glad you could both be here. We will be hearing argument by Zoom this morning in number 23P 431, Darren Whitman versus Department of Correction. Each side will have 15 minutes. There's no rebuttal. We have read your briefs. We've looked at the relevant parts of the record. And so our suggestion would be to get right to the heart of your argument. And with that, Mr. Whitman, why don't you go ahead?
Okay. I'm not good at this, so please forgive me if I don't come across very well. My name is Darren Whitman. I'm serving a natural life sentence for first-degree murder, a crime that I have stated and maintained my innocence to. This appeal from an order of the Superior Court dismissal for declaratory judgment pursuant to MGL 231A was requested for one, to permanently enjoin the defendants from further violations of duly enacted state law, and two, to obtain a determination of the legality of the administrative practices and procedures of the Department of Corrections to house two inmates to a cell despite state law that's contrary to the defendant's practices.
Mr. Whitman.
Sorry, this is back to you.
No, go ahead.
Can I ask you just whether you yourself are currently or have at any time during the course of this litigation been double bunked?
Yes.
So you are currently?
No, not right now. What they do is that they say single cells are a privilege. So you have to go through this long drawn out process of staying out of trouble and to obtain a single cell. But that's not what the law currently states.
And then my follow-up on that would be, part of your argument seems to be that the MCI Norfolk is no longer overcrowded. Yes?
No, in fact, the DOC has seen a significant drop of inmates.
How do we know what the right number is? Is there?
Well, they do. DOC has a fact sheet, a fact card that comes out. If I'm not mistaken, they're currently at, as of July 1st, 2023, they're at 5,477 prisoners within the Department of Corrections. And this is according to the DOC fact card of 2023. Now, in 2009, there were at 2009, they were at 11,173 inmates that were currently housed at that time.
How many are there at Norfolk?
Oh, I do believe it's over 1,000.
And how many cells are there at Norfolk?
Oh, that's a good question.
Let me put it this way. Are there enough cells so that each inmate currently at Norfolk could go into an individual cell? Or would that involve transferring inmates to other institutions?
Well, some of the inmates should not be here. If the DOC would do the proper assessment of individuals with low scores, those individuals would be going to minimums or pre-releases or something like that. A lot of individuals are not even supposed to be here because of their high score. They shouldn't be slated for medium security.
So here's my question. The statute on which you rely, section 22, says, nor unless the crowded state of the institution so requires, shall any two prisoners other than debtors be allowed to occupy the same room. So it doesn't seem like the statute requires DOC to distribute inmates throughout its entire system so that the maximum number can have a single cell. It seems like that's done on an institution by institution basis.
That may be right, but the beginning part of the law clearly states that each person is supposed to be in a single cell. And
Well, I'm not sure what part says that.
Well, that comes at the beginning. It says male and female prisoners shall not be kept in the same cell, in the same room. That comes off that's first part of the law. It also says in there that the commissioner, let me find it here. Come on, where you at?
Mr. Whitman, we can look at the law itself. My question is, were you allowed to get any information or discovery from DOC as to how many cells there are at Norfolk and how many inmates they are currently at Norfolk? Were you able to get that information?
No, I did not ask, and that was my fault. Like I said, I'm new to this. This is me bringing it forward. I did not think to request that. But I would tell you like this, they have a unit that they started here maybe about 6 months ago, where they said, okay, we're going to start this as single cells. So they started moving people into unit 7-1 that they decided they wanted there in a single cell. If that's the case, then why haven't they done it with the entire institution? The entire institution should be single cell. I mean, this will be in keeping with rehabilitative progress and everything else. Right now, we're sitting here and we're going through more problems, dealing with drugs, dealing with theft and things like that. And this is because you have too many people in one place doing absolutely nothing. And
well, Mr. Whitman, I understand all those issues, but my understanding of your lawsuit, it's specific as to the fact that you're alleging that the institution is violating the statute because they are double bunking when it is not overcrowded. So
right.
what the Superior Court needed to look at was, is there overcrowding and is there double bunking? And I'm not sure there was enough information, and I'm not faulting you. I understand you're not a lawyer. I understand you may not have requested it, but that is the sort of the gist of your lawsuit. Am I correct?
Yes. Yes. It basically, I'm just saying that 127.22 should be implemented as written. It calls.
Can I ask you a question on that? And they're admittedly older cases, but we have some cases in our court, in the Supreme Judicial Court, that talk about situations where there are problems with sanitary conditions at correctional institutions and enforcement of Department of Public Health regulations. And those cases seem to say that the solution for someone in your spot is to contact the Attorney General's office, and then the Attorney General's office would have to sue or try to force the institution to do something different. Why is this a different situation where you as an individual inmate get to file this lawsuit on behalf of everybody, basically?
Well, I wasn't so much doing it for everybody. It was just, first and foremost, it was something that I seen. We're held to a standard when it comes to following rules and regulations and everything else. When this was brought to my attention, I'm like, well, why isn't the DOC following it? So my thing was, I asked about it. The deputy superintendent said up there, well, if we got to do it for you, we got to do it for everybody. Where's the state law? Yes, you do. So they never got back in contact with me. Put in the grievances and everything. What am I supposed to do?
I wanted to ask about the grievance. Did you ever get a final decision on your formal grievance? Or was the last thing that you heard that they were extending the time for response?
No, the final decision, if I'm not mistaken, was that they said single cells was a privilege and they denied it. So I'm like, okay, where is this saying that this is supposed to be a privilege? Because there's nothing written that says that single cells is considered a privilege.
Okay, so just to make sure I understand, though, so in the record of this case, we do have the I believe a copy of the notice from a grievance official within the institution that they were extending the time to respond. Did you hear something from them after that?
Yeah, that's when they gave me the now. They said the single cells is a privilege and left it as that. So once that occurred, I took it further. I took it to court. Because once I started looking further and I didn't see anything that suggested that single cells was a privilege, I'm like, then where are they getting it from? Even their DOC policies does not reflect none of this stuff. If anything, if they created a DOC policy when it comes to housing, the authority on that would be 12722, separation of prisoners. I mean, by its very name, it tells you how the prisoners are supposed to be. They want the legislation wanted the prisoners housed. Now, I understand that you have the emergency clause and things like that. Well, if you're going to contend that Norfolk is doubled up and it was appropriate, then what started it, all this doubling up in the first place? Because there has to be a start point somewhere for this to go for this to start. You have a law that strongly says we're supposed to be single cell, unless there's an emergency. Well, what's the emergency? What was the emergency? Because the last time I looked at when we had a influx of inmates coming into the institution, that was back in the 80s when they got the tough on crime bill. We don't have that now. In fact, we got the decarceration bill that's saying that, listen, prisons are to be, more inmates that got to be let go. And this, did you
get cleaned out pretty well during COVID? I know a lot of the institutions did.
For me, yeah, because I'm in my 50s. I'm not trying to catch anything.
No. My question is though, during that time period, a lot of there was a pretty good push to reduce the population. Did that happen where you are?
I do believe some people left. I can't say how many left, but I've known a few dudes that attempted to do it. They got denied and then ended up passing away. You know, and one has to think, what's going to happen to me? I'm working on my case. I'm trying to get back out there in the streets and everything. I don't want to die in here. But you got to, from my standpoint, if I don't take responsibility or if I don't think about myself more, I can't rely on the DOC to do it.
May I ask, Mr. Whitman, when you have been double bunked in the past, have your cellmates been convicted of first-degree murder or only other crimes?
I've been in cells with people of all kinds of crimes.
I guess what I should ask is, have you been in a cell with someone who has not been convicted of what you might call an infamous crime? Because the statute uses that term.
Yes, I have quite a few times, both infamous and non-infamous. But I've actually got into a fight that got me put in a hole over the fact that I have a medical issue. I got into a fight. I got, guy jumped on me. I defended myself. I went to the hole for it. I shouldn't have to go through that because I have a medical condition, and it requires me to use the bathroom. He didn't like that. I told the administration, well, they done nothing. And the end result was me getting jumped on. I shouldn't have to go through that. No one should have to go through something like that, especially when you have other ways of dealing with things. Put inmates in a single cell the way they're supposed to be. There'll be far less of a negative atmosphere within the institution, especially at Norfolk. You got too many people here that's not even supposed to be here. There's been an influx of people from maximum security prison. I'm like, a lot of these dudes don't even have the score, the points to come down to a lower security, but yet and still they're here. And it's been a big problem. So why should anybody walk around looking over their shoulder just to make sure that they're caught up in anything? But that's my issue is, listen, this law is self-explanatory and it should be followed. In fact, it tells the commissioner to make sure that they make rules and regulations that is following the actions that is written in the law. But there is none. There is none. So where do we go from here?
All right, well, your time's just about up. So unless other members of the panel have further questions, we'll hear from Attorney Gordon for the Department of Correction.
Thank you, Your Honor. Richard Gordon for the Department of Correction, and may it please the court. Your Honors, first, I'd like to start by stating that this case was decided on a straight Rule 12b6 motion to dismiss. So I was not aware that Mr. Whitman was housed in a single cell. I'd suggest to the court that would moot this case, even if it is now on appeal. But even if it isn't moot, Your Honor, the lower court, Judge Cloutier, did correctly dismiss this case. She did not rule on a blank slate, judges. There were three cases that I cited in my memorandum, albeit federal district court cases involving three federal district court judges, all of whom held that this particular statute, General Law 127, Section 22, does not create a private cause of action. And she expressly adopted that in her endorsement of the motion to dismiss.
So, Attorney Gordon, if there is a clear violation of the statute, and I think we're going to get to in a few moments, at least from my perspective, whether there is a clear violation, but assuming there is a clear violation, what is an inmate supposed to do?
Well, as Justice Brennan pointed out, certainly contacting the Attorney General's office to have a private suit. Certainly the Attorney General has the ability as the chief law enforcement officer of the state, of the Commonwealth, to enforce this statute. And so that would be the first recourse. And I'd note, Your Honor, that oftentimes these double bunking types of issues might involve something where there's an altercation between cellmates or some such thing where there's an actual injury, in which case, the inmate would have a cause of action for alleged failure to protect. Certainly if, say the statute states that male and female prisoners shall not be put in the same room. And if we do that and there's an incident, certainly there would be a cause for damages under 42 USC 1983. So there are other remedies other than simply relying on this statute.
Why not a grievance? And then seeking judicial review if the grievance has been finally determined.
That's an interesting point, Justice Sachs, that I hadn't thought of. I certainly had not read Mr. Whitman's complaint as asserting a review of a grievance, which is why I filed the straight motion to dismiss. I read it as solely relying upon the statute.
Well, those are also relying on the declaratory judgment statute. So even if there hadn't been a grievance, why isn't that a permissible way of asserting a violation, a continuing violation of a statute against a state agency?
Well, Your Honor, I think to assert, a grievance review type claim under 127 Section 38H, which is a statute that's available to inmates, they have to sort of stylize their complaint in such a way that the attorney at the Department of Correction is on notice that that's what they're doing, so that we can file an administrative record, and that the administrative record will presumably state, what the grounds, what the grievance coordinator did to investigate the claims, what the superintendent did to deny the appeal.
Well, it sounds to me like the record is pretty good on that, in the sense that Mr. Whitman filed the grievance and the response was, which is problematic in my opinion, that it's a privilege to be single bunked. It seems to me the statute doesn't say anything about privilege. It seems to me it's the opposite. It's the default position, according to the statute, is they're supposed to be single bunked. And it's the institution that decides by, and I'll quote your brief, unless the crowded state of the institution so requires.
Yes, Your Honor, that is what the statute states. There simply aren't enough bunks to single bunk every single inmate. And so as a result, inmates can get a single cell through a number of mechanisms. First and foremost would be if there is a medical or mental health need for that inmate to be in a single cell. Certainly those types of orders do occur.
So is it the institution's position, and I would love to ask specifics if you know them, which I believe, I can't remember which one of my colleagues asked Mr. Whitman, is, are there 1,000 cells and are there more than 1,000 inmates currently at Norfolk? What's the numbers?
Your Honor, none of that is in the record. Again, it was decided on a straight Rule 12b6 motion to dismiss. So none of that is in the record.
Well, except you're arguing in your brief that unless the crowded state of the institution so requires. So what is the crowded state of the institution which so requires that this statute not be followed?
Your Honor, I'm arguing first and foremost, and the reason that Judge Cloutier allowed the motion to dismiss is that there's no private cause of action here.
And if we don't adopt that, let's move on to the next argument.
Yeah, absolutely, Your Honor. Whether or not the crowded state of the institution requires that some inmates be double bunked is certainly something that is left to the sound discretion of prison administrators. And I'd point the court to a couple of other statutes which have to be read in harmony. Certainly the statutes which delineate the commissioner's duties and responsibilities and powers, and certainly the statutes that delineate the superintendent's powers to take charge of the institution.
But your argument—
Can I just stop you for one second? Do you agree that designation is based on seniority and good behavior? Those are two of the criteria.
Yeah, absolutely. Absolutely.
What authority do you point to? And maybe that's where you're going. What authority do you point to for the commissioner to designate single cells on those bases?
Well, certainly the commissioner has authority to classify and transfer inmates. I mean, that's in 124 section 1. That's in the transfer statute.
Right, but I'm talking about designating, saying within a particular institution, saying, okay, we only have a certain number of single cells available, and so the way we're going to figure out who gets what is if you're on good behavior, if you've been around for a while, and on good behavior, you get the single. And as opposed to, where does that come from? It seems to me that it's not, I mean, it makes sense, but it seems rather arbitrary in the more generic sense.
Again, Your Honor, I think it emanates from the general laws that I stated, the duties and the powers of the commissioner and the duties and powers of the superintendent, which are in the general laws. In addition to the cases over the years holding that there's no right to a single cell, Bullfish, going back to Supreme
right.
Court.
There may be no constitutional right, but the statute does seem to put certain rights on when the commissioner can house certain kinds of inmates together. My question is, under the other statutes that you cite, the commissioner may well have some discretion to determine whether the crowded state of the institution requires. But is that discretion reviewable by a court? Could a court say, look, the undisputed facts are, and they're not shown here, obviously, but hypothetically, could a court say, look, the undisputed facts are there 1,000 inmates, 500 inmates at Norfolk. There are 1,200 cells. And yet they're all double-celled. And the commissioner doesn't have any explanation of why that is, other than that single celling is a privilege. Could not the commissioner's decision be reviewed either on review of an individual grievance or under the declaratory judgment statute for abuse of discretion?
I suppose it could be reviewed in the sense that if the hypothetical that you posed, it might sound to cause unconstitutional conditions. Certainly,
No, I'm just talking about a statutory violation.
Again, Your Honor, I think that it would be, that case involving the DPH regulations against the Sheriff's Department. I think it would be up to the Attorney General's office to have to bring.
Why? Why doesn't the declaratory judgment statute allow a court to review what the commissioner did and is doing on an ongoing basis, if that were proven, for abuse of discretion? I mean, I don't know that you've cited any case that says the declaratory judgment statute is not available, or that, for that matter, the grievance judicial review statute is not available.
Yeah, Your Honor, the grievance review statute, I'll be honest, that one caught me by surprise. I hadn't thought about that, and it wasn't raised.
This did start at the grievance, right?
It did. Well, they have to, Your Honor. I mean, you have to exhaust, as you well know, Justice Sachs. I mean,
and did he exhaust?
I believe so. Yes, I did not argue, failure to exhaust under the Prison Litigation Reform Act. I just never read, usually an inmate would have to plead in his complaint that he's seeking judicial review of a grievance. I read it as certainly him stating that he had a statutory right to have a single cell. And for that reason, I moved to dismiss, because there's a number of cases, as I stated, federal cases that don't bind this court, but I would say are persuasive, that there's no private cause of action under this statute.
Well, they might be more persuasive if they had considered and rejected theories of review that involve the grievance or declaratory judgment. But I didn't see any of the three federal cases that you cited considering either of those theories.
No, Your Honor, and I don't think that. I mean, look, if Mr. Whitman was asserting a claim for a grievance review, I mean, it's certainly news to me. I think it's up to him to plead it. And pro se complaints are construed liberally. Sure, the cases very much stand for that proposition, but I have to be on notice to address things when they're, whether or not that's a count. And I didn't see that anywhere in the complaint.
Counsel, is Norfolk overcrowded?
Norfolk, the court can take notice, I suppose, of the fact that that the inmate count is down, Your Honor, but also that the number of facilities in the past several years has closed.
I'm not asking about facilities, and I know maybe I'm going outside the record, but I'm going to ask it again. How many cells are there at Norfolk, and how many inmates are there currently in Norfolk?
I don't have that. I am happy to find those two numbers out and submit a 16L letter if it will, if the court wishes.
I would appreciate that.
Yeah. So, Your Honor, just so I am clear, you want to know how many inmates there are today and how many cells there are?
Correct.
Yeah.
It seems to me, again, if you black letter of the statute, and I know there might be other reasons why the commissioners say there's overcrowding, but again, hypothetically, if there are 1,000 cells and there are 1,005 inmates, that to me would be legitimate for the commissioner to say the crowded state of the institution requires at least some double bunking. If there's 1,000 cells and there's 800 inmates at Norfolk, then there might be an issue. Again, that's just, I'm reading black letter. There might be other reasons, but.
Your Honor, I will have a 16L. Oh, I'm sorry.
How fluid is that number? I'm trying to get it, because I looked at it the same way Justice D'Angelo did, but I'm concerned that that number is fluid, that the number of folks who might be sick or have mental illness or otherwise need to be segregated for safety reasons is a fluid number. It just, that's my concern when we start to.
I mean, people are coming in and out. People are coming in and out at all times, Your Honor. You might have inmates who are wrapping their sentences, inmates who are getting paroled, inmates who are going to lower custody. And then in the same token, Your Honor, you might have inmates who are going to higher custody. As you said, people going to hospitals, people going to the state hospital or to outside hospitals because of medical issues. It is completely fluid on any given day, but
Your
you know,
16L
the
would be a
justice,
snapshot. It's a snapshot. And for example, the day after, the day before, the week after, it could differ or not at all. Or it could differ substantially, not at all. Is that your thought?
it could very much differ, but you know, to Justice D'Angelo's point, I'll get a 16L letter by the end of the week with today's number.
And maybe you could just tell us as well what the fluctuation has been within the last month or the last 30-day period or whatever, because I can see how even if there were 1,000 cells and on one particular day there were 999 inmates, if you know that you've got people coming back from the hospital or needing to be transferred from other institutions, you can't transfer an inmate to a single cell necessarily. If the next night he's going to have to be bumped back to his original cell because you got to make room for somebody who actually, needs a single cell because they have enemies or whatever it might be.
Yeah, and Justice Sachs, you might have a situation where you need to keep a single cell open because you might assume if there's an emergency, you need to separate inmates or some such thing. None of that is in the record, but I will, to Justice D'Angelo's point, I'll get today's number, and to Justice Sachs's point, I'll get 1 month ago's numbers, I should say,
okay.
And submit a 16L letter by the end of the week.
Thank you. Unless there are any further questions from the panel, and I'm not seeing any, that concludes our argument. Thank you both very much for your able presentations, and we'll take the case under advisement. And that concludes our Zoom session. We will resume with hearing other arguments in a few moments from the